So very good afternoon everyone. So in the previous session we have completed the concepts of Doctrine of Constructive Notice and Doctrine of Indoor Management. Two topics are completed. Now in the today's session we are going to start with next area called as a Doctrine of Ultravires. So Ultravires illa, Ultravires. Sir, listen. So it's called as a Doctrine of Ultravires. So we completed constructive notice and indoor management, but in that one small area is still pending for us to complete. Exceptions to the Doctrine of Indoor Management, in that only one exception I have completed: knowledge of irregularity. Director's example at the last. But still two more examples are still pending for us. One is a suspicious transaction, another one is, the first one is suspicious transaction and another one is a forgery case. Two other points are also still pending for us to complete. Once we complete that, we go to the Doctrine of Ultravires. Once the Doctrine of Ultravires is completed, then we go to section number 10. That's where we will be understanding why the members will be called as insiders for the purposes of indoor management and constructive notice. Please, no noise, everyone settle down first. Shall we continue? So in the previous class we started with Doctrine of Constructive Notice and Doctrine of Indoor Management. So 1.5 hours we spent on understanding the basics, cases, everything we have completed from the exams point of view. But still, let me first do a 2 minutes revision on the concept of indoor management and constructive notice. Once we complete that, we go to exceptions once again. Number 1, Memorandum of Association and Articles of Association once registered with the ROC will get the status of public documents. Therefore, every person dealing with the company must have the knowledge of all the contents of the memorandum and articles in a right sense. If a person who does not have the knowledge of memorandum and articles in a right sense cannot file any suit against the company. Therefore, the concept of Doctrine of Constructive Notice is a doctrine which protects the company against the outsiders. Therefore, the doctrine is working in favor of company and against to the outsiders. So this is what we have seen in the previous class with regard to the Doctrine of Constructive Notice. And yet another concept is there, Doctrine of Indoor Management. Constructive Notice, name is very clear. Company will presume that you have the notice of, that means company will construct in its mind. Okay, company will construct in its mind that you have the notice of MOA and AOA. That's why the name is called as a constructive notice. Next, once you read the contents of MOA and AOA in a right sense, okay, how company presumed that you have the knowledge of MOA and AOA, from then you will be having the presumption right of thinking that companies have done whatever is to be done as per MOA and AOA perfectly. So therefore that's a presumption which works in favor of outsiders and against to the company. So it is to protect the outsiders against the company. Indoor management name is very clear. The most important line we need to write in exam is, the outsiders need not inquire into internal management of the company. For example, in AOA it is written, company has to pass a special resolution. Now I will presume that whatever is there in the articles, company is also doing that. Clear? How you are presuming that even though I don't read, you presumed that I have read it. Now I will also presume that whatever is there in the AOA, that you have done perfectly inside your company. That's why I will make a presumption on indoor management of your company, means internal management. I will also presume that everything has gone right. This is a doctrine of indoor management. However, doctrine of indoor management will protect only innocent outsiders against the deeds of the company, not just outsiders. They should be innocent outsiders. Innocent outsiders in the sense they should not have any knowledge of irregularity. The person must have read MOA. The person must have read AOA. Understand the contents in a right sense. Fourth one is no knowledge of irregularity. No knowledge of? Yesterday's last example, if you remember, Royal British Bank example, I made some small changes to that. If Turkwan happens to be a director, same answer you can't write, because being a director, you will know whether general meeting is conducted or not. Being a director, you will know whether a resolution has been passed or not. How you can become an innocent outsider? You become only an outsider. So doctrine is not just to protect the outsiders. Doctrine is to protect the innocent outsiders against the misdeeds of the company. So this is what we have discussed in the previous class. Hope you remember the concept at least, everyone. Now listen carefully. Some other exceptions are also there. See here. I will give you some examples as to how it can occur. See here. Doctrine of constructive notice, 6 points are there. I will give you a minute time for you. First revise all the 6 from the notes. Once you are done with this, then we will be going into exceptions. 6 points. Take a minute time, complete it fast. Six points completed. A constructive notice. Everyone. Now read the indoor management 4 points. If you don't write any of these points in exam, 1 mark cut. He will ask indoor management for 4 marks. 4 points you need to write. If you leave any of these points, marks cut. All the 4 are 4 golden rules of indoor management. Once an outsider read the contents of MOA and AOA and understand its contents in a right sense, he will stand protected by the doctrine of indoor management. Next, an outsider can presume that as far as internal regulations or resolutions are concerned, company has complied them strictly. That means he need not inquire into the internal management. How you didn't inquire me whether I have read the MOA or AOA, I will not inquire whether internally have you done everything correct or wrong. And last but one, this is a doctrine that operates in favor of outsiders and against the company. Thus, the doctrine protects innocent outsiders against the wrongs done by the company. So this is what covered by the doctrine of indoor management. For this, there are 3 exceptions. Exception number 1 is a knowledge of irregularity. Means even though you are an outsider, even though company didn't pass a special resolution, you read MOA and AOA, even then you will not be protected if you are falling into any of these 3 categories. Number 1, very good, please read. If the outsider is having the actual knowledge of irregularity, the doctrine will not protect him, since the doctrine protects innocent outsiders. Clear, everyone? This is 1 point. What is the next one? Negligence or suspicion. About this I will discuss very clearly. Please listen. I will give 2-3 examples also. Tell me. What are all the conditions required to get protected by the doctrine of indoor management? Number one, some people are not in this world. Very good afternoon, everyone. Please be in this class. We started now. Tell me, what is the step number one? What is the condition one to get protected by the doctrine of indoor management? Number one, read MOA, read AOA, understand in a right sense. Next, these three are satisfied, then I will be protected by the doctrine of indoor management or not? But I should not have a knowledge of irregularity. So no knowledge of irregularity. I should not have a knowledge of irregularity. Clear, everyone? If all these four conditions I could satisfy, that means I read MOA, I read AOA, understood the contents in a right sense, and I don't have a knowledge of irregularity. If all these conditions are satisfied, I will be protected by the doctrine of indoor management or not? Yes. But one small exception still persists. Listen carefully. The point is, I will give you one classic example. Same example with a slight different change. It happened in another case law. Patent Ivory Manufacturing Company versus Howard. It's a case law, Howard versus Patent Ivory Manufacturing Company Limited. This case law happened. What happened in this case law? Let me explain first. Company is a principal. Board of directors of the company will be the agents of company. Repetition. Company is the principal. Board of directors of the company will be agents of the principal, agents of the company. Company is a artificial person or natural person? Can company do anything on its own or cannot do? Who should do on their behalf? Directors will be doing that. Hope everyone understood the concept. This was said in section number 179. 179 is a charging section for the board powers. See a final syllabus. 179 subsection number 1. Sir, for clarity's sake, I will show you, only for understanding sake, how really the director's powers are given. Which section? 179. Okay. Hopefully it is visible, everyone. Right, Aham? Sir, I will zoom in. Everyone? Now clear? Which one? Which section? 179. What is the name of the section? Powers of the board. What will be the powers of board? What board can do? If the question arises, some answer should be there or not. That answer will be given by section number 179. 179 said that the board of directors of the company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. What it said? The board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Clear? So I am making it small. See here. This is what they said. The board of directors of the company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Provided that in exercising such act or doing such an act or a thing, the board shall be subject to the provisions contained in this behalf in this act, memorandum, articles or regulations not inconsistent therewith and duly made thereunder, including the regulations made by the company in a general meeting. That's what provided by the first proviso to section number 179 subsection 1. Next one is the board of directors shall not exercise the powers which are reserved only for the shareholder. That means it may be provided by the articles, memorandum, act or any other agreement to be exercised or to be done only by the company in a general meeting. And last one will be no regulation made by the company in a general meeting shall be invalidate any prior act of the board, provided it is valid if the regulation had not been made. That's what about section number 179 subsection number 2. Later the powers of the board are given. The board of directors of the company shall be exercising the following powers only by means of passing a resolution at a meeting of the board, namely, making calls on shares, authorization for buyback, issue of security, borrow money, invest funds of the company, to borrow money, invest funds of the company. Next one, to grant loans, give guarantee, provide any security, to approve the financial statement, to diversify the business, to approve merger, amalgamations and takeovers. All these are given in section number 179, subsection number 3, A to K. These are the clauses in 179.3. If you observe all these things, whose powers these are? But not in your syllabus. For that one good reason you are saved. So 179 subsection number 3 will be talking about the powers of the board of directors in a company. What are all the powers? What they can do? They can do everything. That's not I am telling. 179.1 has enshrined it very clearly in its provisions. 179 said that the board of directors of the company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. See here the words are company is authorized. Company will be authorized to do. What company can do? It will be there in the objects clause of MOA. What company can do? What is the motherboard, CPU, brain of a computer? Like that brain of the company is objects clause. Clear everyone? Everyone understood how a computer will have, whenever you buy a system, whether you are buying a AMD Ryzen or whether you are going for a Intel Pentium i9 processor, like that name is that name clause. Where each and everything should be located is a situation clause. But what it has to do, it has to be kept in the form of a chip. That will be the objects clause of memorandum that decide what you have to behave. So what company can do? Sorry, I will tell like this. What board can do? Answer is whatever company can do. Everyone repeat. What board can do? This is not the way. Left speaker not working. This entire speaker. Maybe you realized or not, I don't know. Right speaker, okay, good. Thank you, thank you. So listen. Thank you. Overaction and they are telling overaction. Sorry, listen. Point is, listen. What board can do? Whatever company can do. Everyone repeat. What board can do? What board can do? What company can do? Whatever the board can do. Very good. Very good. Nice performance. What company can do? Whatever is there in the objects clause of memorandum. Everyone repeat. What board can do? What company can do? Whatever is there in the objects clause of memorandum. Aur ek baar. Repeat. What board can do? Whatever company can do. What company can do? Whatever is there in the objects clause of memorandum. What board can do? Whatever is there in the objects clause of memorandum. A equal to B. B equal to C. A equal to C. Yes. So, same rule applicable. What board can do? Whatever company can do. What company can do? Company can do whatever is there in the objects clause. So, what board has to do? Whatever is there in the objects clause. If a board of directors does anything beyond what is there in the objects clause, we call them ultravires. So, those are called as ultravires transactions. If they gone beyond what is there in the memorandum, because you are doing what your system can do. You are doing what your system cannot do. It has some restrictions, it has some limitations, it has some prohibitions. You are crossing the boundaries, you are deviating and you are doing. Those are called as ultra wires. Sir, that discussion will put it separately. Sir, first, why I am asking all these questions is, see here. Company has to do something. Who should do? Board can do. Company has to borrow. On behalf of company, who should borrow? Very good. Company has to do something. On behalf of company, who should do? Adi. Always remember, board is the dota to the company. He is a Ramaduta type. Okay, who is Ramaduta? Hanuma. Like that, who is a Hanuma for company? Board of Directors. Clear everyone? Sorry. Now listen. Listen. Enough. So the main point I want to explain is the nature in which they behave, the company and the board of directors. Please see what happened in this case. Howard versus Patent Ivory Company Manufacturing Company Limited. Howard, please listen. Howard is a money lender. Patent Ivory Company la accountant is there. Mr. T, not chartered accountant, normal person who will manage basic accounts in the company. Okay. Huh? BCom, okay. Don't underestimate BCom. Sriram business in Mumbai, BCom people are more talented than chartered accountants. Sriram business school in Mumbai, those people are more talented than chartered accountants in India. They are going for MBA finance in IIM. So don't underestimate BCom. BCom, if you do in a wrong university, it may be bad. But if you do in a right university, it's bigger than anything. Sir, anyway, I'm not to debate on that. Sir, listen. So, Howard versus Patent Ivory Company. Howard is a money lender. Sir, listen please. Patent Ivory Company is there. In that company, there is an accountant with the name T. Some person. Okay, accountant. Sir, listen carefully. This Mr. T went to the money lender. Went to the money lender. And Mr. T said that our company, Patent Ivory Manufacturing Company Limited, requires a loan. Requires a loan. Loan is required. Okay. Howard has asked for, first tell me, as a money lender, what documents Howard has to ask? He took MOA. Next, what he has to ask? AOA also he took. What he has to do after that puja? Puja to AOA and MOA. What he has to do? Read means read should not be like what you read in class. It should be read in a correct way. So reading should be in which sense? Every single thing he has done. And he don't have any knowledge of irregularity. Even then irregularity also not there. Everything is going well. Clear? Now listen. Tell me. Howard has taken the MOA or not? Yes, AOA? Yes, read? Yes, understood in consensus? Yes, knowledge of irregularity? No. Irregularity is not there. Everything has gone correctly. Clear everyone? So what he has done? He issued a check to the T. T took that check, ran away. Over. It's a bearer check at that time. It happened in 1929. At that time, case law. Account payee checks are not so popular at that time. Bearer check. Whoever have the check, money will be tendered to that party. Later, RBI in India also cancelled in the year 2008. Bearer instruments are cancelled in India. We will discuss more about that in Negotiable Instruments Act. Okay, not now. So, bearer instrument is there. He has given a bearer check. That person took the check, went to a bank, encashed money, taken into pockets, ran. Over. 1 year completed. Howard went to Patent Ivory Manufacturing Company. He asked, my money with interest if you give, I will go. Patent Ivory Company saw him up down. Who are you? I am. So he asked, I am Howard. So what? So what? You are Howard, okay. We are Patent Ivory Company. So what? So what means if you give my loan, I will go. Which loan? Who are you? I have given loan, no? No. No, you didn't give. Hey, I have given. No. To whom? To that fellow. Some tea. He went for tea and didn't come again. So, we don't know where he is. No trace. Arey, I have given to him. That's your mistake if he run away. I have validly read the MOA. Everyone answer, had he read MOA or not? Yes, sir. AOA? Yes, sir. Read? Yes, sir. Understood? Yes, sir. Everything, whatever is there in indoor management has constructive notice. I satisfied or not? Now he has given money. Money to whom? To accountant. Accountant ran away. He didn't give money to the company. Over. He said that I have given you money. To your company only I have given. He said your company name only. Therefore you have only to pay me. They shown balance sheet. On the balance sheet, did your name is there in the liabilities side? You check Howard. Howard name is there on the liabilities payable side. He said, no, that's your problem. Accountancy, you didn't write my entry properly. Matter went to the court. Court also given the same judgment. Point number 1. Is there any mistake on the Howard person is a question now. He read MOA or not? AOA or not? Read it or not? Understood in a right sense or not? All the conditions of constructive notice has been satisfied or not? Court also said that, Howard, you are not protected. Then he is shell shocked. I satisfied each and every condition of indoor management. And why I will not be saved? I should be saved. They said that negligence. When someone comes to you and asks for money, don't you make a basic inquiry? Who the hell is? Who he is, don't you ask? Sir, today accountant came. Tomorrow person roaming on the road will come to you. He will tell, I am from TCS. You give money and go to TCS, huh? Did you understand the point, everyone? Answer. Yes, sir, I will ask you one question. You only answer. Some person, and this is very popular in the recent times, over the Facebook, some person will put a message, I am in a need of funds. Over the Facebook, we are getting messages. Same profile will be created. From that person's profile, we will get a message. Some XYZ will put a message. He says, how are you, Kaushik? I am in a need of fund, 2000 rupees. Please transfer through phone pay. This is the number. They will ask or not? Yes, if you pay to them, it's a mistake of whom? The other person, mistake of us. Yes, it's our mistake. Same way. Whoever tell the name of our company, you will give money to them. How can you understand that accountant will have a right to take loan on behalf of company? Tomorrow watchman will come, give also to him. Whatever company can do, that should be done only by whom? Answer. Whatever the company can do, that must be done by the accountant is a board of director. Then why you have given to him? Today you have given to accountant. Tomorrow some person on road will come. He will tell, I am from Patent Ivory Company. Give him check to him and ask company. Did you understand the point clearly? So, I will give one example. Some outsider came to you. He said that Kaushik sir is there somewhere in Pondibasar. He is in a need of fund. His wallet lost. Okay. He is in a dire need of fund. He need 5,000 rupees. If you give me, I will give to him, you said. If they ask no one, please don't give. Okay. No one give. No one. Because the person to whom you are giving, what is the guarantee that really he will bring to me? Are you understanding or not? Yes, answer here. Yes, one person is there who worked with me in the last 10 years. Really, one person is there with me. He is my student. He is also completing CA. He is in CA final. Only one group left, group 2. He is working with me since the last 6 years when he joined CA foundation. Now he was a CA final. So he continued. Every one of the person who ever transact with me or do any commercial business or a profession with me, everyone know him. Okay, he only does all the posting of all advertisements, everything he will only do. If that person comes to you and asks, there is a chance you can give to him because one reason, there is an establishment of a agency and principle between me and that other party. Clear or not, everyone? Acts of that person will become the acts of me. But my accountant acts will not become the company acts because he is not the agent to the company. Who is the agent to the company? If board of directors, like any of the director came to you and took the money by saying the name of company, you would have saved. That means even without making a basic inquiry as to whom you are giving the money, you have given the money, kada. Therefore, for the negligence and suspicion, protection will not be available. Negligence, suspicion. Suspicion means what? Doubt. How accountant will have a power? You should have got a doubt at least. Yes or no, everyone? Read now. If, please read. If a transaction leaves an amount of suspicion, the outsider has to inquire and clear the suspicion involved, or else he will not be protected by the doctrine of indoor management on the ground of negligence. Sir, why I am laughing also I will tell. I said him exactly 3 o'clock he should be here. Yesterday he made a delay. That's why he is showing me time. One clap to him. So listen carefully. So if the transaction leaves an amount of a suspicion. Sir, in the example, please listen. Come back please. Howard versus Patent Ivory Company example. Howard is an outsider who has common sense, no common sense. Why? When an accountant comes to you and asks for a loan, first you should call the company and inquire or not. Your accountant came to me. Really, do this accountant have a right in your company to take loan or not? You should have asked that question or not, everyone. Yes, sir. Sir, really some outsider comes to you and said something. Kaushi Mukesh want money. If really you want to give, first you should ask me or not. Yes. Sir, one person came to me, his name is so and so, he is saying that you are in need of money. Can I send money with him? You have to ask or not? Yes, without asking, you gave money. That person ran away, you came to me and said, sir, one person said your name and took money, therefore you pay me money, why I will pay? Are you understanding? Not you, any person I am talking about. Yes, everyone understood the logic of this concept or not? Yes, this is protecting, it is an exception to the protection. Yes, now tell me, read the statement properly. If the transaction leaves an amount of suspicion, the outsider has to inquire and clear the suspicion involved, or else he will not be protected by doctrine of indoor management on the ground of negligence. Now after 15 minutes, once we complete Ultravires, I will call you on the stage, I will give you the case study, you should answer. Get ready everyone in the class. Yesterday, KVS was a CRM case. Everyone remember a mortgage deed deficiency? Fantastic. Next one, RBB versus Turquand. Howard versus Patent Ivory Company. So now, forgery I have clearly written in the chart. Which chapter we have to refer, sir? Share capital chapter. Share capital chapter. The last two concepts are there. First one is blank transfer. Second one is a forged transfer. Tell me. What are the two? Blank transfer, forged transfer. Two kinds of concepts will come. Next chapter we are going to start. There I will cover that forgery case. There one case law is there. Reuben versus Great Fingal Consolidated Company Limited. Very, very important case law. 8-9 times already tested in exam. That case law analysis, judgment, everything I will explain not here. It is more appropriate if I discuss that point in share capital chapter. But remember, if there is a forgery, what will not protect you? Indoor management will not protect you, though you have read MOA, AOA, understood it in the right sense and no knowledge of irregularity. Yes, so now tell me, first, indoor management will protect whom from whom? Outsiders are company. Against the fantastic. Next one. Indoor management protect the outsiders against the misdeeds of the company. But that protection is available if and only if you read MOA, you read AOA, understand in a right sense, no knowledge of irregularity, no negligence or suspicion, and no forgery. Like this you have to write in exam. But in examinations, what institute is doing in the recent trend is, they are not asking indoor management. They are asking directly what are the exceptions for 3 marks. Means you have to write exception. First exception is knowledge of irregularity. And you need to keep a heading and write this 1 mark. Clear? And they will ask negligence or suspicion. This 1 line you will write 1 mark. Forgery, I will show you the point in share capital chapter. You have to write that another 1 mark. 3 marks gone. Clear everyone? Like that he is asking. Rather than asking entire indoor management, they are directly asking exceptions to the doctrine of indoor management. First point, everyone tell me, understood this concept or not? Yes, sir. What is the concept we completed? Constructive notice, indoor management, exceptions to the doctrine of indoor management. All the three completed. Okay, please, I am putting it before you. Take a minute time. Complete these concepts one last time before I ask you the questions. Once you are thorough with this, we go into ultravires. Please read. Doubt, huh? Yeah. No, you need not write always. Sometimes implied authorities will be there. Directors only will have that implied authority also again. Accountant can never have an implied authority. It can be given, but it is not written there. Yes. If it is, no, accountant can never have the power. He didn't even ask who you are. You should ask company at least whether this person has a right to take loan or not. That option is there with you. Yes. Sir, please, no noise. Please, everyone. Same sound you also make when I call you on the stage, please. The same voice, what you are putting now, please also put the same on the stage. Okay, please. When you are talking, you should also talk on the stage in the same way, please. You asked it out. Who is asking? Yes. Yes, correct. Everyone, please read Doctrine of Constructive Notice properly. Once you complete constructive notice, next one will be the indoor management. After that, exceptions. Once you are thorough, then we will go to ultravires. When we are discussing ultravires, we will complete one rule of interpretation called as rule of Ejusdem generis. Interpretation rule is there. That rule, 9 rules of interpretation. I think you have written notes, kada? Yeah. Notes not an interpretation. 9 rules. What I said at the end of the first chapter, all interpretation what we learned in this, we will write in interpretation of statutes book. Last we have put the page. Let this chapter get completed, then we will write. But before going into that, 9 rules of interpretation are there, if you remember. Rule number 1 will be rule of literal construction, rule of reasonable construction, rule of harmonious construction, rule of beneficial construction, rule of exceptional construction, rule of Ejusdem generis. Next one is called as a noscitur a sociis, contemporanea expositio, expressio unius est exclusio alteris. These are the various rules of interpretation applicable in law. I told you to write that at the beginning. In that one of the rule we are going to complete today. What is the rule? Rule of Ejusdem generis. Rule of Ejusdem generis. When we come to the audit and auditors, there we will see rule of exceptional construction. Rule of exceptional construction. There we will see that. And in general meetings chapter, we will read the rule of harmonious construction. Clear? Harmonious construction we will see. When we come to the chapter called as dividends, we will see the rule of beneficial construction. Like that, in each chapter, wherever required, we will make necessary interpretations and close them. Clear? Whatever the interpretation is not completed in any of our chapters of the syllabus, separately we will read in the interpretation chapter. 80% of the interpretation chapter we will complete along with the Companies Act. If any balance is still left out, that we will cover separately in the interpretations of statutes chapter at the end. Clear, everyone? Before going into that, have you read all the points here? Yes, next, also read the indoor management. At least 60% of the answer you should tell to me when you are on the stage. Ensure that you are answering this properly. Persons who are already given chance on the stage yesterday and day before may also be called once again. Please don't be under wrong impression. Okay? I was already called, happily I can sleep in class. No, don't be under that wrong impression. Sir, today we'll show one sample on that also. 1-2 persons who have already said will come on the stage. Now you will also believe that I will call. Read properly. Indoor management. Once you complete, I will put the exceptions. Also read the exceptions. Hello, bro. Hey. Exceptional indoor management. So read also the negligence and suspicion. Completed. Can I go to the next one? So now we completed the doctrine of constructive notice, indoor management, exceptions to the doctrine of indoor management. Now next area will be ultravires. Doctrine of ultravires. Two topics are there in doctrine of ultravires again. One is the doctrine of ultravires, and second one will be talking about additional concepts on ultravires. Okay, this will be the impact of ultravires transaction, and this will be the case law called as a Ashbury Railway Carriage and Iron Company Limited versus Ritchie. If you remember this case law, we read in foundation also. There we understood in one way Here, with the rule of interpretation, I will explain the same. There you read the case law, I said the summary of case law, what happened, everything I explained. But here, with the rule of interpretation, we will understand why court have given the judgment. Foundation law, what is the case you have seen? Now we will see why court has given judgment like that, we have to see. Same happens also with my income tax, everything. Whenever you read the case law, foundation leave off, there we should know what. Here you should know why also along with that what. Clear? Your own inference you have to apply. Practically you need to see the case. Sir, okay. Anyway, when we come there, I will explain the facts of the case, everything. Lastly, I have given the verdict given by the court. This is the court that has given the judgment. I have put here. These are the facts of the case. Clear, everyone in the class? Shall we continue? Everyone on the screen, please see there. Doctrine of Ultravires. And moreover, I am telling you very clearly, I mean it to say, till classes are conducted, till my classes are over, every single session maximum possible, I will call you on the stage. You fix it. First point, a big chapter, a small chapter, easy or difficult, none of our business. Okay, if you can cover the syllabus, if you can revise in the class, if you can re-revise in the class, if you do everything in the class, there is no need to read law once again. That's what I always strongly believe. So classroom should not only become a place to take the notes, so you should also be a place of revision, because the revision what you do here will be times more powerful than whatever you do at home. Clear? So therefore please complete everything in the class itself. Don't take the burden of law to home. So anyway, see there. Doctrine of Ultravires. Here two words are there. One is ultra. Ultra means beyond. Wires means powers. Powers means actions of the director. Powers means actions of the director. Beyond means what? Over. So what is ultravires? Yes. Perfect. Now you got to know what is the real meaning. So therefore, the word is, I am not joking, really the meaning of the word ultravires is overaction. But act can't write like that, na? General English language and foul language. Therefore, what they used is ultravires, beyond the powers. Beyond the powers is called as what? Ultravires. Not virus. Who is telling virus? It's not virus, bacteria. It is what? Wires. V-I-R-E-S. Wires. Sir. Okay. See here. Please. Doctrine of Ultravires. Now answer my question clearly. I will write one word. Is there any meaning to that or not? First you tell me. Started, Very good. Not overaction, it is not doing whatever is required also. Within action also it is not doing. Sir, listen please. Please. You don't do, listen. What is the name? Now tell me, per se this word has a meaning or not? Everyone? This word is having a complete meaning or not? Answer is no, because beyond the powers of what is a question. Beyond the powers, okay. Beyond the powers of dash. That's the question. Beyond powers of, okay, beyond the powers of dash. No. That's, one second. Don't get excited. Concept A new. Foundation, what you learned is a drop in ocean. Now you are seeing only sand inside ocean. Real ocean you will see in final. Anyway, at that time, you will read it as a self-module. So please listen carefully. Please see there. Ultravires. Ultra means beyond. Powers. Okay, beyond the powers of what? Is a question. So this doesn't have any meaning unless and until you tell this. Tell me what this is. Then I can give some meaning to this. Clear everyone? So what is ultravires? is having no meaning. Ultravires, what is a question? There are 4 situations. Ultravires dash will have 4 answers. Ultravires, the act. Ultravires, the MOA. Ultravires, AOA. Ultravires, board powers. Everyone tell me what are all the 4? Ultravires, the act. Ultravires, MOA. Ultravires, AOA. Ultravires, the board powers. These are the 4 kinds of ultravires transactions that are possible. Clear or not, everyone? Before going into this, first tell me, what do you mean by ultra? What do you mean by wires? Beyond the powers of dash. Act, MOA, AOA, board powers. Clear, everyone? Okay. Now listen. Don't read those now. First point number 1. Whenever you have done any kind of ultravires transaction, first point number 1, transaction will become legal or illegal? Legal or illegal? Everyone? Second one, because of its illegality, it becomes valid, void ab initio. I think you know void ab initio difference. Pakka, done. I don't want to waste time in explaining them. Next, company liable or not liable? Because board is doing what company can do, board is doing what company cannot do. Board is doing what the company cannot do. Therefore, you are only liable. Therefore, company liable or not liable? Not liable. Next one. Not ratifiable or ratifiable? Not ratifiable. Meaning, I will tell later, directors will become personally liable. This is the first thing. So, these are all the impacts of what? Ultravires transactions in a company. Everyone, please listen. This is the impact of an ultravires transaction. Clear or not, everyone? So the impact of an ultravires transaction is the transactions will become legal or illegal? Illegal. Valid or void ab initio? Who is not liable? Who is liable? Ratifiable or not ratifiable? Meaning of ratification I will tell you later. So see there, 4 types of ultravires transactions can be there. What is the first one? Ultravires, the act. Ultravires, the MOA. Ultravires, the AOA. Ultravires, the board powers. These are the 4 types. Clear? Okay. Let us now understand the concept. First, let us go into one case law. Thereafter, I will come back and reanalyze this concept. First, I will give you one case study just to understand. Try it on your own. After that, I will give you solution also for that answer. See here. Okay, see here. Okay, this was opened. Anyway, I came here. Sir, if you remember, I said about Spice Plus form to you or not? Yes, sir. How many parts will be there? 2 parts. This is the part A. Okay, na? Recently we incorporated one company, Navier Machines Private Limited. For that, this is a Spice Plus form. Sir, what is this? Part B. What is Part B talking about? If you are, Part B do not talk about structure of company. Part B will talk about so many things. Okay. In that, what is the first one? Whether the articles of association is entrenched. We clicked on no. Company is having a share capital. This is the equity. This is a preference. So you can see here, PWS Sales Block, Narsingi, Rajendra Mandal, Hyderabad, like that. We have created the company. So register of companies will be there. Having it in or not having it, they will ask the details. Along with that, we need to give the details of the directors. Let me show you. So like this we need to give the details of the main person. His mother is one of the director. So her details we have to give. So like this they will ask the details. Another person is also there. That person's details also we have to give. So once you give all the details, then we have to attach, I told you now, proof of evidence, proof of identity. See, one person has given a proof of identity as a passport. One proof of residence has been given for the bank statement. Shares are subscribed, everything they will promise. These are all optional information to be filed. This is a stamp duty details. Once company is incorporated, now PAN automatically gets generated to company. Along with that, TAN also will get created. And this company is coming under PGBP. What head it is coming? Business or profession, PGBP. Business code is called as a 12. See, these are the attachments. First, what is that? Memorandum, articles, declaration by first subscribers, proof of office address, proof of utility bills like electricity, etc. Resolution passed by promoter company. These are all details. Okay? After that, we have to give a declaration that all the things are correct, everything is going right. After that, we have to sign. This is called as a pre-scrutiny form. If you remember, I told you. What is this? Pre-scrutiny. Check form. We need to first click on check form. Now the button is inactive button. Originally it will be a gray color active button will come out, pop it out. We have to click on that, check the form. After that, what we have to do for the form? Pre-scrutiny. Once you pre-scrutiny, submit. Online it will be submitted. I think now you can relate it to what we discussed now. This is what exactly we do at office. All these filling will take 4 hours time. 25,000 pakka. Pakka 150%, because we don't reduce that. That will be general charge that everyone will take. But still, what I want to tell is, for the work done and the payment get, it will be definitely more. Am I clear? So it's easy work also, not so great, not so difficult also. So anyway, 1 minute, I will show you an example. You can try to give the answer. You are seeing Ashbury Railway Company case, Lana. This is what I have done for the previous batch. These are only made as a charts. First I have written in the class and I made it into charts. This is what we have written for them. Full chapter, whatever you are seeing as a handwritten charts now. Now you are seeing a printed charts. Last batch those are handwritten. It used to be like this. Those were printed into that particular format. So, array, 1 second. That is my duty. Listen carefully. My point, sir, array. Don't deviate the concept here. 1 second. Let me tell you one important case law with regard to this chapter. Try this. I will give you one info. From this you make your try, whether correct or wrong. See here. There is a company called as X Limited. This company is having a paid up share capital of, say for example, rupees 100 crore. Free reserves 30 crore. Securities premium account 20 crore. This total is 150 crore. Okay, point number 1. Next, listening everyone. Same example, now I will ask you the questions. At that time, don't come with a blank face and answers. Give some answer to that. See the screen. Paid up share capital, 100 crore. Free reserves, 30 crore. Securities premium, 20 crore. What is the total? 150 crore. This is the overall capital net worth of that particular company, some X Limited. When we are on case studies, please show some importance on that. Don't do overaction, okay? Everyone on the screen. Point number 1, over. Number 2, this is the situation. Company has made already existing borrowings. Existing borrowing, that means already on the balance sheet liability side. Long-term liabilities like loans from banks, debentures, etc. Already it is 120 crore borrowings are there. Clear? Now company want to make a new borrowings, also called as a proposed borrowing of another 50 crore. Another how many crores, sir? 50 crore. Now, this extra, how much they want to borrow? Come from the beginning again. Tell me, what is the total of the net worth? What is the borrowings existing? How much extra they want to borrow? Very good. 50 crore. Now listen. There is a section called as section number 180, subsection number 1, clause number C. Repeat. 180, subsection 1, clause C. Sir, I will give one history about this section. 181C is a section which talks about the borrowings of a company. When last interbatch started, like you, at that time I came to 181C. I have shown the bare act. If you have any of your seniors who studied from me in the last batch, ask them whether I said this in deposits chapter or not for them. For you, I am telling in this chapter, kada? For the last batch, batch D of the last batch. For them, I have clearly mentioned 181C, read, please read, I said. Students generally have a tendency to do overaction when I say something in class. With a lot of 10 years of loaded experience, we will tell something by expectation, they don't do. Yesterday's exam, 8 marks question came in examination, the latest enter attempt from same 181C, though not there in the syllabus, because it's an amendment. This amendment has affected 2 chapters, Incorporation chapter and Deposits chapter. I said them very, very clearly. 180, though not there in your syllabus, he will ask. He will definitely ask that question. Do you know why? Institute study material 181C section came. You are having institute study material? Huh? Yes, sir. Institute study material is there? Huh? Please, anyone give me, I will show you. Where that 181C was kept, please give me, sir. Not bare act, institute material. I will show you, I will tell the page number also. If you have doubts on that, you can also check it. It is in page number 5.14. Page number 5.14. Page number 5.14. 5.14, the first sentence is there, however exemption, however as an exception. Do you see the? Yes, and a private company may accept from its members monies not exceeding 100% of aggregate of, that's why in the board what I have written, paid up share capital, free resource and securities premium. Clear? Sorry, that is one evidence. Please come over to page number 5.18. Have you seen 181C? Words also given there, see there. 181C. However, an eligible company which is accepting deposits within the limit specified under 181C may accept deposits by means of an odd resolution. Given or not given? That's why I said it will be given. Generally, final topics they don't ask in inter, but reference is given in study material. Then they have every liberty to ask question on that. I said very clearly in the class, he will ask this question. They didn't read that question, came in exam. First question in paper, 8 marks. came from 181C merging with the deposits. So, when I am saying something, I am not doing any storytelling here. If it is really storytelling, I will only tell you, then you sleep or you do other works. Okay? So, please listen carefully. 181C says following. If existing borrowings plus proposed borrowings, everyone repeat. Now I will discuss. Deposits chapter when we come, I will tell. In the incorporation chapter, I already discussed this. At that time, don't put blank faces. I will tell you here only very clearly. Existing borrowings plus proposed borrowings. Everyone repeat. Existing borrowings plus. If it exceeds, okay, if it exceeds aggregate of, guess the answer, paid up share capital plus free reserves plus securities premium, special resolution is required. In deposits chapter, instead of special, he said ordinary. That's the amendment. Clear? Normally it requires which resolution? Special resolution is required. For our understanding as of now, remember special. Tell me, what is LHS? LHS, existing borrowings plus proposed borrowings. If they exceed what? Aggregate of paid up share capital, free reserves and securities premium. In this case, which resolution is required? What is the logic of the lawmaker? The idea is very, very clear. If you are, listen, debt equity ratio is crossing 1:1, special resolution is required. Existing borrowings plus proposed borrowing crossing net worth means what? 100:100. My paid up share capital, free reserve, securities premium is 100 rupee. Existing plus proposed borrowing is also 100 rupee. Means what is the ratio maintained? 1:1. If that debt crosses ratio of 1:1, special resolution is required. If that debt crosses 2:1, unanimous approval is required under Companies Act. That's when ratio analysis chapter, ideal debt equity ratio will be placed at 2:1. Okay. Logics, everything we can see there. Liquidity ratios, everything we can see that. But the main point, the logic of that particular issue is, when the debt exceeds your equity, whose permission you should take? Shareholders. By passing? In a? Fantastic. Now I have a question for you. First tell me, what 181C says? Where existing borrowings plus proposed borrowings exceeds aggregate of paid up share capital, free reserves and securities premium account, then company has to pass a special resolution. This is what said in which section? 180 subsection 1 class C. This is what said there. Okay. Now my question. Now you should tell me the numbers. What is the paid up share capital I have written? 100 crore. Free reserve? 30 crore. Securities premium? What is the total? 150 crores. I will call it as a ceiling limit. What is the limit? Ceiling. Up to that borrowings can go directly. Now tell me, existing borrowing is 120 crore. Proposed borrowing is 50 crore. If you add EB plus PB, it is within the ceiling limit, beyond the ceiling limit. Now tell me, I want to borrow a proposal of 10 crores only, not 50. Special resolution required or not required? Then whose permission required? Board of directors only. Okay, na? Next, if it is 50 crore extra, it crosses the ceiling or not? Then who will borrow? Board A will borrow, but with the extra permission of the shareholders in a company. Everyone understood the point or not? What board can do? What board can do? General question. What board can do? Whatever company can do. What company can do? Whatever is there in the objects clause of memorandum. That means if there is something in the objects clause of memorandum, that can be done only by whom? Board of Directors. Shareholders' powers are always, remember this, approval powers. They don't do any idea bringing powers. Clear? Idea will always comes to the mind of Board of Directors. Implementation time la permission will be given by, that's all. Work is always done by board. Permission to do that work is given by shareholders. That's the work of the shareholders and Board of Directors in a company. Everyone understood or not? So tell me, paid up share capital freeze or securities premium, how much is the ceiling limit? 150 crore. In this case, I am within the ceiling, beyond the ceiling. Now tell me, special resolution required or not required? But not passed. What will be the consequence is my question. Wait. Roko ek baar. First you do one thing. Did you understand the point what I asked you? Ultravires understood? Now on this footing, I will first put you before 181C as a my duty is to first make you to read that section. Which section? 180 subsection 1 clause C. Please read what is 181C. Restrictions on powers of the board. Read. The board of directors of a company shall exercise the following powers only with the consent of the company by a special resolution. Namely, C point we have to read. C point. To borrow money where the money to be borrowed together with the money already borrowed. Stop there. What is the power first? Borrow. Where the money to be borrowed means what? Proposed borrowing. Together means what? Addition. Money already borrowed. What do you mean already borrowed? Will exceed, aggregate, paid up share capital, free reserves, securities premium. Stop there. Had we decoded that properly or not? Everyone? This is the wordings. So the point is very clear. Law want to tell that to borrow money where the money to be borrowed together with the money already borrowed will exceed the aggregate of paid up share capital, free reserves and securities premium apart from the temporary loans obtained from the company's bankers in its ordinary course of business. This is what actually said in 181C. But for interlevel, we don't need to read what is temporary loan, everything. But idea is very clear. To borrow money, where the money to be borrowed, together with the money already borrowed, will exceed aggregate of paid up share capital, free reserves and securities premium. This is the idea. It requires which resolution? Special resolution. Very good. I have my responsibility is to show the bare act. I have shown that. Now you understood now? To borrow money where the money to be borrowed. What is to be borrowed? Okay. To be borrowed. Together with the money already borrowed. What is the money already borrowed? 120. Is it exceeding? Paid up share capital is how much? Free reserves? Securities premium? How much is the total? Here how much is the total? 150 exceeds 150 or not? Which resolution is required? Passed or not passed? What will be the consequence? That's the question. Now did you understand how the question can be tested to you? Listen. This is how a question can be asked with regard to ultravires. If really I were given a chance to prepare your CA inter question paper, I will give this question for 8 marks in exam by giving numericals and understanding to what extent student has understood the concept of ultravires, etc. I will give this question in exam. Okay, if you know, whoever have the concept in mind, they will write. Remaining, chalo. Gone, 8 marks. You can write other questions. Other questions also I will give that way only anyway. So in this chapter, this is a question. Another chapter, another question. Now did you understand the question, everyone? Now listen. I will write the answer. With this, at least you should understand the point clearly. See here. When I am writing, don't copy. Please Follow the points clearly one by one. Two situations can occur. Roughly I am writing. Don't expect neat handwriting here. Roughly I am trying to explain everything. See the screen. Two situations can occur. Situation 1 and situation 2. Situation number 1. Memorandum of association is, or I will write like this, borrowings is not warranted by MOA. Borrowings are not warranted. Please listen. Borrowings are not warranted by MOA. Warrant means power. That means borrowing power is not there in the memorandum. Yesterday I told you, if something is not there in the MOA, company can never do that. So I read entire MOA, nowhere borrowing power is there. First situation. Second, borrowings are warranted by MOA. First, you should tell me the answer. Borrowings are warranted or not warranted? First case. Everyone? Now tell me, company don't have any power to borrow, but it has borrowed. Company means company will borrow, board of directors will borrow. Now tell me, what will happen to the board of directors of a company? First tell me, can they borrow as per MOA? They borrowed or not borrowed? Borrowed. Now tell me, what happens to the borrowings? First, illegal or legal? Because they are going ultravires the MOA. In my MOA, borrowing power is there or not there? But they borrowed or not borrowed? That means it is legal or illegal? Tell me. Valid, void ab initio. Next. Company liable, not liable. Directors personally liable, not liable. Next one. Ratifiable, not ratifiable. Sir, okay. Sir, okay, please, see here. Up to here, everyone understood the point? Yes, everyone? Yes, sir. Borrowings are warranted by MOA. Now, two situations can arise. Two situations can arise. Situation number 1. Situation number 1. Special resolution passed, special resolution not passed. First tell me, there is a company. First situation, that company has a power to borrow, not having a power to borrow. Second situation, having a power to borrow. Next, special resolution, sorry, I will make it in another way. Within limit, let's make it more complicated. Beyond limit, SR passed, SR not passed. Like this you can imagine another two different situations. Everyone, give the answer clearly. First, what is there? This is not acceptable. Everyone in the class answer, what is there? First case, company has a right to borrow, no right? Second case, first case, no right by MOA, but still board borrowed. Now it will be Ultravires the board, Ultravires the MOA. Therefore it becomes illegal, void ab initio, company not liable, directors liable, not ratifiable. Understood the first set? Next, borrowings are warranted or not warranted? Warranted by MOA. Now it is warranted by MOA. It is within the limit or beyond the limit? First case. First tell me within the limit. Okay. 120 crores existing. 10 crores only I want to excess borrow. So special resolution required? Not required. Special resolution not required. Now tell me, transaction is valid, void, illegal, legal? First tell me, legal or illegal? It is legal. Nature of transaction, valid, void, voidable, what it is? Everything has done perfectly. It is valid. Next, who is liable to repay? Director's liability, yes or no? Ratifiable or not ratifiable? Your head not applicable. Some answer we have to give like an idiot. Concept of ratification does not arise. Some answer we have to give now. Tell me, first case, within the limit or beyond the limit? Within or beyond? Now tell me, special resolution required or not required? Nature, valid or void? Liable, whom? Directors liable or not liable? Ratifiable or not ratifiable? Next case. Beyond the limit. Beyond the limit. Yes or passed or not passed? If you cross the limits of 181C, you have to pass a special resolution or not? Had I passed or not passed? Same situations will apply once again. Tell me, transaction is, nature is, liability on, directors, very good. Ratifiable or not ratifiable? Not applicable. Perfect. SR is not passed. SR is not passed. So tell me, SR is not passed. So tell the answer now. SR is not passed. What will happen is a question now. What will happen is a question now. Everyone listening? Two situations will come again. Okay? SR not passed. If SR is not passed, it is illegal or legal? Irregular. Amidst of both of them, there is a third thing. These are called as irregular. Example I will tell you. Tell me first, company has a power to borrow loan or not in this company? Yes, sir. Who can borrow on behalf of company? Who actually borrowed? Come from the beginning again. Whether this that's why come out from sleep. See there. Company has a power to borrow, has no power to borrow. On behalf of company, who should borrow? Who actually borrowed? Ante company has a power to borrow, board has power to borrow, board only has borrowed. Act done is correct. The way in which you have done is wrong. You can't tell it totally valid. You can't even tell totally it is invalid because it is the middle of both of them. Totally not valid, but totally not even invalid. Those are called as irregular. Means act done is correct, but the way in which you have done is wrong. Clear everyone? Yes, those are all legal, illegal, irregular. Legal, illegal, irregular. Valid or void? Voidable. Amidst of both, another thing is also there under Contract Act. It is not totally valid. It is not totally void. It is middle. Void ab initio. Sorry, voidable. It is not totally valid, illegal. It is not totally illegal. It is irregular. Tell me now, company has a power to borrow or no power to borrow? First case like yes or passed or not passed? Passed. Therefore transaction is legal or illegal? Nature of illegality is valid. Liability on? No liability on? No liability on? Ratification concept is applicable or not applicable? When everything is correct, why ratification? Okay, over 1 point. Next issue. Second, company has a right to borrow, na? Company has a right to borrow, they borrowed, on behalf of company, who should borrow? Who borrowed in this case? In this case, it is within the limit or beyond the limit? Yes or required or not required? But passed or not passed? The act done is correct or wrong? Correct. The way in which they are doing it is correct or wrong? What they would have taken? But they have taken permission. Therefore, the act done is valid, but the way in which they have done the act is not valid. In such case, we call it as voidable. What is that? Voidable. Whenever I tell voidable, you have to remember one point clearly. There are 3 types of transactions. How you can close a transaction on the basis of validity. Everyone repeat contract act. There are 3 transactions in which you can close. You can close any kind of contract in 3 ways. 3 validity of transaction. Number 1, valid. Number 1, valid. Number 2, valid. Number 3, everyone, I can close a contract in how many ways? 3 ways. Like this, you should not think only 2 ways. Valid, void. Voidable can't close. It can start as voidable. It should take the shape of valid or void, because it is valid or void in the option of the aggrieved person. Sir, I will explain a point. Say for example, take one person, she is there. This property, this building belongs to her. Say for example, okay, this property, that book is the title deeds of this building. She is putting with her. Sir, listen, I took a sharp knife, kept on her neck, and I said, sign on the documents in my name. Okay? Sir, listen to the concept, please, listen. So I said that I kept a knife on the neck, and I said that sign on all the documents in my favor. I will bring a stamp paper, you sign there. I will also sign. I signed on stamp paper, she also signed. Now she signed with a free consent, coercion. When coercion is involved, contract is valid or void? Voidable. Because she signed out of a coercion. Signature was there. There she will write, after signing her name in the bracket, she will write, this signature is out of coercion. No. Then how can I understand by seeing a signature, this is a coercion signature, this is a normal signature? How can I understand? No one can understand. If I see the signature, I believe that you signed with a free consent. Unless or until you yourself tell that there is a coercion. Clear? Now tell me. Coercion done today. Registration of property has done after 15 days. In this 15 days, like any one of the day, you would have gone to the court and filed a stay order against this transaction saying that Kaushik Mukesh obtained my consent out of coercion. You could have filed a case or not? Yes, 15 days she complained silent. Your silent will be taken it as a free acceptance. Estoppel. Clear or not, everyone? Yes, your silence will be taken as a acceptance. Sorry, second case. I kept a same concept, story, screenplay, let's change. Same knife, same person, same property, same documents, everything is essentially the same except her act. I went to her, kept a knife on her neck, coercion, she signed. Registration has a gap of 15 days. During this 15 days, she went to the court and filed a complaint saying that Kaushik Mukesh has obtained my consent out of coercion, or else I wouldn't have sold this property, she said. Now, suddenly a voidable transaction is taking a turn into void contract. First case la voidable it started, but it take a turn of valid. Second case la voidable take a turn of void. That means, can a contract close as a voidable? No, a contract can only start as a voidable, but it has to take the shape of void or valid. Same happened here. Further to I am explaining all these things. Act of board. In this particular scenario, board has borrowed or not borrowed? Who can have a power to borrow money in a company? Who actually borrowed? Act of the board is correct or wrong? Correct. But they have to take whose permission if the limit exceed? They have obtained or not obtained? Therefore, the act of board is correct or wrong? Correct. The way in which they have done is wrong. Those are totally illegal? No. Totally illegal? No. Those are called as what? Irregular. Totally valid? No. Totally void? No. Those are what? Huh? Therefore, ratification chance is there. Subsequently, you get it ratified. You have to take the permission of shareholders before taking loan or after taking loan? Did you take or not taken? So take after taking the loan. That's called as ratification. Subsequent approval. Ratification means what? Subsequent approval. Two situations will come. Ratified, not ratified. Everyone repeat. Ratified. First, say for example, it is ratified. It is a ratified. Ratified by whom? Ratified by whom? Shareholders. Okay, now tell me, if ratified, again same answer will get attracted. Okay, transaction will turn into legal, valid, company, no liability on directors, now ratifiable. Not applicable, we ratified it. Clear or not, everyone? Last situation, ratified or not ratified? Summarize everything. There is a borrowed or not borrowed? Borrowed. Who borrowed? Within limit or beyond limit? Special resolution passed or not passed? Transaction is valid or illegal, legal, irregular? Valid or void, voidable? Ratifiable or non-ratifiable? Ratifiable or not ratifiable? Ratifiable. But actually ratified or not ratified? Now tell the answer. What will happen? Transaction is legal or illegal? Transaction is 100%. It's a legal transaction because MOA is permitting you. You didn't take special resolution, no doubt. The transaction is a legal transaction to the company. Okay, but you should tell the nature. That legal transaction is now turned in. Sir, all void transactions are not illegal, but all illegal are void. What you learned in Foundation CA, Contract Act. Common sense you have to learn before learning Contract Act. First point, that's what we are missing here. You are thinking that void means illegal. All void need not be illegal. All illegal are void. Here illegality is there, only void nature is there. Void nature of a legal transaction is there. Are you understanding the point or not? What is there? Void nature of a legal transaction. Tell me, all illegal transactions are void. No, true or false? Ganalahari Madhir repeating. Tell me, all illegal transactions are void. Yes or no? All void are also illegal. Means you are only agreeing that all void need not be illegal. That means there can be legal void transactions also. It falls into this. If memorandum A is not giving anything, then it is illegal. Understood the point, everyone in the class? Now what we have to do? Repeat from the beginning again, because you gave wrong answer. Even if you shout, same thing I will do. If you don't want, go out of the class. Listen carefully from the beginning. What is there? Company. What is there? Company. Company. Who taken the loan? Board will really have the power? Yes, has taken? Yes, within the limit or beyond the limit? Yes or passed, not passed, valid, illegal, illegal, legal, irregular. It is admissed of both. Transaction is legal, but the way in which they have done is irregular. It is totally void, totally valid. Then what it should be? Voidable. Ratifiable or non-ratifiable? Actually ratified or not ratified? Sir, everyone understood? If not ratified, voidable will turn into valid, void. This is a void transaction. This is what we have to learn in Contract Act. Always all illegal transaction here will be void. Mean this is a meaning. It is legal, but void. Okay, sorry. Transaction legal, nature is void. Now tell me, who is liable? Who is liable is a question. Who is liable? Who is liable? Very good. Next, sorry, company liable or not is the question. I'm very sorry. Company liable or not? No. Directors liable? Directors liable or not liable? Now tell me. Outsider can recover or cannot recover? Cannot? Cannot. This is a valid or void. First you have to tell that. Void transaction. Outsider will have a rights or no rights? Answer. He will have. That's the power of indoor management. If you prove that you read MOA, AOA, understood in the right sense and no knowledge of irregularity and no suspicion, and the company has done the special resolution mistake, outsider can recover the money. Even the transaction is void. That's the power of indoor management. That's to tell. Everyone understood the point? It is an exception to the Contract Act. Contract Act la void transactions, none of the parties have a right. But in Companies Act, indoor management crosses the boundaries of Contract Act and provides a provision like this. Everyone understood the point clearly now? Actually, this is what I want to ask in exam. So, merging Contract Act, Companies Act, consent, free consent, valid, voidable, ratification, not ratification, mixing all these things, prepare a DJ. So, this is how a question can come. Okay? Sorry. Understood the point clearly, yeah? Now, what? Hey, listen. Please. Ratifiable or not ratifiable? Second, last case, not yet completed, sir, answer. Still there. Last, one climax. Not ratified or ratified? Transaction legal or illegal? Legal. Nature valid or void? Company liable or not liable? Directors? Outsider can recover or cannot recover? Everyone, don't tell that answer. Outsider can recover or cannot recover. Here doctrine comes. If he prove that he is good faith today. 1 second. I know what you shouted now. Now tell me. Listen. Sorry, okay. Please. Transaction has beyond ceiling, within ceiling? Yes sir, passed, not passed? Illegal, irregular? Ratified, not ratified? Valid, void? Valid, void? Outsider can recover even if it is void? Depends on whether he has proved the good faith. Good faith means what? Read MOA, read AOA, understand in a right sense, no knowledge of irregularity, no suspicion. If I can prove, forgery, okay, leave off. That's in share capital concept, okay? If I can prove all these 5, I am said to be in good faith, or else I am not said to be in good faith. If I am in a good faith, can I recover or cannot recover? Cannot. If I am not proving that I am not in good faith, cannot. Within the limit I can recover even though I don't prove good faith, because special resolution is not required up to 120, 150 crores. Again two branches will come. Did you understand the point? Some people are still in cloud. Come back. Listen. All this problem has come because of which resolution not passed? Special resolution is required within ceiling or beyond ceiling? How much is the existing borrowing? Sleeping again. 120. Okay, what is the ceiling? Up to what? SRA not required? 150. Muttal. What is the total limit? 150. What is the existing limit? 120. What limit I can borrow without passing any resolution? That 30 can be recovered even though you don't prove good faith, because for that SRA not required. Within ceiling limit, beyond ceiling limit. Within ceiling recover, beyond ceiling not recoverable. This is 30 crores say you can't recover. This is how you can ask a question in exam. Okay, everyone understood? Beyond 20 crores. 20 crores you cannot. Beyond ceiling, within the ceiling limit. What is the limit? 120. What is the ceiling? How much I can? 30 within the ceiling. This you can recover. The balance how much is there? 20. That you cannot recover. That means indoor management will not protect you only to this. This irrespective of indoor management you can recover, because up to the 30 SRA not required. This is how you can ask a question in your exam. Not tested till now in exam. Maybe or may not be, I don't know. But if really I were given a chance in the next year and after that, if really a chance was given to prepare question paper, now beautiful 8 marks question we can prepare on this. Okay. That's all God grace. Daivecha. Sir, okay, everyone. Understood the concept clearly? Yeah? Enjoyed a lot? Yes, take a break and come. So let's continue. So before the break we came to know about how to understand the concept of indoor management, and when it will apply, all these things are completed. On that we have to read these concepts now. See here. One second. See here. I have one small question to ask in that regard. With regard to the question what we have done now, that illustration. See here. Everyone understood this case study clearly? Yeah? Yes, so first situation, to summarize on a overall basis the entire concept. First one, there is a company. That company want to give a loan or borrow the money? Borrow the money, take a loan. First situation, borrowings not warranted by the MOA. Legal or illegal? Legal or illegal? Very good. Valid or void ab initio? Company liable, not liable? Directors liable, not liable? Ratifiable, not ratifiable? Next one, borrowings warranted by MOA. In that case, within the limit, special resolution required or not required? Beyond the limit, special resolution required or not required? But passed or not passed? Passed. In that case, again legal. If it is not passed, okay, if it is not passed, in that case what will happen? Now question number 1 for you. Everything discussion was completed. First situation, borrowings not warranted by MOA. It is ultravires, not ultravires. Ultravires, not ultravires. Ultravires. But borrowings are warranted by MOA. Listening. Borrowings are warranted by MOA beyond the limit. SR is not passed. SR is not passed. Therefore, it becomes which transaction? Irregular. It becomes a irregular. Board has a power to borrow only up to what level? 150. But they borrowed how much? Extra how much? Extra how much? Borrowing power is there in the MOA or not? Borrowing power is there in the MOA or not? But board can borrow only up to how much? They borrowed up to how much? Okay, now tell me, this transaction is ultravires, not ultravires? Come from the beginning. See here. First situation again. So when you give wrong answers, don't make sounds. Okay? Because you have given wrong answers, I am repeating once again. Okay? If you are giving wrong answer, what does it mean? You didn't understand. What is my duty? Repeat once again. What I am doing? Then why overaction? See there. If I continue, even though you give wrong answers, then you should make sounds. Why sir is not clarifying our doubts? Why he is rushing into next concept? Why we paid fee? You should question me. Rather you are asking me to rush through this. If you didn't understand, what you should ask, sir, repeat once again. If you didn't understand, ask again to repeat. If you didn't understand for 50 times you ask me to repeat. If I don't repeat, then you have a right to question me. We paid fee, why you are not repeating? In class, reverse is happening. You paid fee and I am requesting you, I will repeat. Okay? Listen carefully. First tell me, what is there? Better, I will write a separate simplified chart to this. You will answer this. There is a? Okay. Borrowing is warranted or not warranted? Second case, borrowing is? In this case, not warranted, but still they borrowed. It becomes ultravires or not ultravires? Very good. This is, in this case, warranted or not warranted? Borrowing can be made or cannot be? Two situations can come. Within limit, beyond limit. Within limit, beyond limit. Within limit, SR required or not required? Beyond limit, SR required or not required? But SR passed, SR not passed. Or I can tell this, in this case, SR has been passed. Here SR is not passed. SR is passed means transaction is ultravires or not ultravires? Not ultravires. It is within. In this case, it is ultravires. In this case, here it is pakka case of an ultravires transaction. Clear? Now tell me, ultravires is illegal or legal? Ultravires is illegal or legal? Illegal or legal? Illegal. Okay? Now here, this particular transaction, see this slot. Okay? It is ultravires or not ultravires? Everyone. Ultravires the board powers, intravires the memorandum, those are voidable and ratifiable. This is what given in your institute study material. For this explanation only, last 1 hour discussion I have made. Shall I show you where in the study material it is? Give me study material once. I will show you where all these topics have been given. Thank you. Received. Tell me where the Doctrine of Ultravires. Okay. Come to page number 2.23 in your study material. If you don't have study material, no problem. Please see here. So 1 second. Okay. Page number 2.23. Okay, see here. Okay. Everyone in the class, please see here. Enough, please. In case of a company where whatever is not stated in memorandum as the objects or powers is prohibited by doctrine of ultravires. Not stated in the memorandum. What I said to you in the yesterday's class, if something is not given in the memorandum, can company do or cannot do? If you do, what it will become? First one, that's a point here. Next, as a result, an act which is ultravires is void, and it will bind company or will not bind? Will not bind. That's why in our example, we said it is void ab initio. Company liable or not liable? Not liable. That's what he is telling. It will not bind the company. Okay? Okay, next. Can be ratified or cannot be? Apply your mind properly here. Ultravires transactions are illegal, I said na. Can be ratified or cannot be? Read the last line. The company cannot make it valid even if every member assents to it. Means even 100% of the members tries to ratify it. You cannot ratify. General rule is that an act which is ultravires the company is incapable of ratification. An act which is intravires the company but outside the authority of directors may be ratified. That's what the case law summary is. Now I have taken one example, loan, etc. Loan amount I have taken. Sir, that question will really come in exam, sir. Do you know, whatever the facts and figures I have taken, facts are same, figures I changed just to understand. It may be 77,63,162 rupees, like that real numbers are. For understanding sake in the class, I made it 100 crore, 120 crore, like that. All the example what I have taken from the case law called Rajendranath Datta versus Shailendranath Mukherjee, 1982 case law. Happened in Supreme Court of India, Appellate Tribunal was made in Calcutta. From that case law only I have prepared that question. So every chance is there, institute can frame a question on that case law and they can give. Clear? Listen carefully. In our exam, that's all. I think everyone at least believe in whatever we are discussing is there. That's all. That's what I want to tell. Listen, in this case, it is ultravires or not ultravires? In this case, ultravires or not ultravires? Ultravires. Ultravires board, intravires MOA. Ultra means beyond board powers within MOA. Intra means what? Intra. When I ask a question at that time, don't dare to give wrong answers. So again and again I am repeating. Intra means ultra means in both cases wires means what? Powers. Intra wires means within powers, ultra wires means beyond the powers. Clear or not everyone in the class? So in this particular scenario, if you observe, okay, ultra wires the board powers, intra wires the board powers, ultra wire. Board has a power to borrow up to, they borrowed up to, it is within the powers of, beyond the powers, beyond the powers of MOA, beyond the powers of board. Can, as per MOA, can we borrow na, cannot borrow na? Can borrow. It is within the powers of the board, beyond the powers of the board, beyond the powers of the board, within the powers of MOA. Those are all ratifiable. That's what study material want to tell. But which student in this world can understand his language? After this much explanation for 1.5 to 2 hours, say situation is like this. They give in a paragraph answers all the points. Now, who will understand those? That's why coaching. So, coaching to be very productive, first you have to understand what really they want to convey. The background, if you understand, then you can really play with the concepts. or else they will play with you in exam. So first point is, listening everyone? Have your own conceptual clarity. Study material answers are direct answers like financial management. Why they will come, God also will not know. Direct problem, the answers will come. But what is the concept? What really the concept want to convey? What really is these numbers coming from? Why we are adding? Why we are deducting? Logic not there. Directly they will put answers. Lala, at least practical answers will not be there. Theoretically they will give. They are direct. See the number. Why that number can? God also should not know. Aham Brahmasmi. I know what God know. I know what God do not know. I know what God should not know. Everything is known by ICI. From where numbers will come, they don't know. Direct numbers. Students see capital budgeting questions and he will get fits. Why those answers are coming? So, logic, approach, background understanding. Direct, see the numbers. Like that here also. Transactions are ultravires, intravires. Which student will understand if you tell directly? Rajendranath Kumar Datta versus Shailendranath Mukherjee 1982 Calcutta Tribunal case means CA interest student, how can he understand? So some background analysis is required for that coaching. So at least do you understand what I try to convey here? Everything is ultravires, but I told you at the beginning, ultravires is a wrong word. Ultravires dash. Four things can happen. Ultravires, MOA, sorry, Act, ultravires, MOA. Now answer, section number 3 we read. A company can be started for which purpose? Unlawful you start na, Ultravires Act. Am I clear? Next, MOA, you have written something, you are doing something else. It becomes Ultravires MOA, void, illegal. Next two things are there na. Ultravires AOA, intravires MOA. Ultravires board powers, intravires MOA. These two are voidable, irregular, ratifiable. Everyone understood the point? On that only our charts are made. Let me show you the final answer for this. Tell me. What is this? See the screen. Types of? Now, which bit I will ask you on the stage, even I don't know, please listen carefully. Types of? What is the first one? Ultravires the act. What is the meaning? Acts done are not permitted by Companies Act. Next one. Ultravires the MOA. Acts done are outside the objects of MOA. In both cases, the impact is null and void. Next. Ultravires AOA. Ultravires both powers. Ultravires AOA means what will happen? Acts done are not in conformity with AOA, or second one, acts done are not within the authority of board of director, but they are within MOA. They are within? They are within? Articles I have written, sir, articles I have written, special resolution has to be passed. Say for example, I didn't follow that. Act done is within MOA, but SR not passed. Then I will call it as what? Ultravires the AOA, intravires the MOA. Those are all ratifiable transactions. Clear? Act done is valid, but the way in which they have done is not valid. Clear? Father, son, father, daughter, any relation you take. He came to 5th class. He or she, whoever the case may be. Gender inequality don't take. When I tell he, General Clause Act applies also to me. Okay? Don't take. So is taking only he, not she. I have a daughter. Okay? So, now listen carefully. Now listen carefully to the point. My logic, what I want to convey is, a father and son is there. He instructed his son, saying that, you study and play. After coming from school, you study first 2 hours. After that, you play for another 2 hours. Go to bed. 5th class or 4th class student. Now, on one day, he first played. After that, he studied. Father came home. Mother started complaining, saying that You said a sequence, na? First steady, next play. But he didn't do that. He played, after that he studied. Now the act done is illegal. Irregular. Whatever the two things you said, he done. But the way in which you asked him to do, he didn't do that way. Now you will excuse or will not excuse her? Those are all ratifiable in Companies Act as well. Everyone understood the concept? Those are all called as an excusable transaction. Act done may not be perfect, but not even illegal. So excuse him. Why so much anger? Kruddhapapam nakuryatkaha kruddho hanyat gurunapi kruddha parishayavacha naram sadhu nadikshipet. Sanskrit la Bhagavad Gita la Sri Krishna said, so anger is not good for you, Partha. So Partha means whom? So anger is not good for you. Kruddhapapam nakuryatkaha kruddho hanyat gurunapi. In Sanskrit, these two dots will come, na? In English, we use the word like this, that came from our Sanskrit, Visarga we call. Two dots will come, na? Kruddhapapam nakuryatkaha. Kruddhapapa means if you are in a deep anger. Okay? Nakuryatkaha. What you will do with that anger? Kuryamu means karyam. Karyam means a work. Kruddhapapam nakuryatkaha. With that much anger, what you will do? Partha, Arjuna, don't have anger, have senses. Kruddho hanyat guru napi. In that anger, you can kill your guru also. Bhishma is there on the other side. So, don't take wrong decisions in anger. Definitely they will go wrong. Kruddha parushaya vacha. In this anger, na, the words what you use also will come foul. Bad language you will speak in anger. Kruddha parushaya vacha. Naram sadhu nadikshipet. In that anger, you will also go to sadhu purushu. Means you will also go to persons who are saints, sages. You will also go to them. You don't have a discrimination or a differentiation between who is good and who is bad when you are in anger. So anger is not good for you. Not even for directors, not even for shareholders. Don't be so much harsh towards the directors of company. Sometimes loan must be taken immediately. At that time I can't wait till the general meeting is conducted for another 5 months after. At that time, in emergency situation, apad dharmam, I will take some decisions. Please ratify them. Why you are so much angry? I didn't do anything what a company cannot do. MOL clearly it was said that I can take loan, I am taking the loan. But sequence I may not follow properly. Now I will take. How he has first done play and later he has taken the study. Like that first I have borrowed, later I will go for ratification. What's wrong? Clear? If it is repeated for 4-5 times, na, father also will not accept it. Like that if this ratification is happening multiple times in the same company, shareholders also don't ratify. They stop ratifying it and make it void. Did you understand the concept clearly? That's the idea behind the ratification concept. Hope everyone understood the concept clearly. Yes, with this, we have completed types. Okay? First, answer my question clearly. What are the 4 types? Number 1. Ultravires the Act. Next, Ultravires the MOA. Next, Ultravires the AOA. Next, Ultravires the board powers. First 2 are null and void. Next 2 are irregular and voidable. These are intravires the Act and intravires the MOA. But maybe ultravires AOA, ultravires board powers. Understood the concept? Now this point you already seen. First 1 to illegal, void ab initio, company not liable, not ratifiable, directors personally liable. I have already written. Type 3 and 4, irregular, voidable, company liable if ratified, directors liable if not ratified. Already I discussed about this concept or not? And last, additional concepts on ultravires. Please read. Ultravires acts do not bind the company. Ultravires act make the board of directors, being the agents of the company, personally liable. Third party cannot sue company. Whom you can sue? Directors you sue. You die. You do both the people. But don't come to company, because I don't know what has happened. Next, objects of the company shall be expressly said in MOA, or else acts become ultravires. This is what we have seen in the study material. First point. If objects clause is silent on anything, don't presume that you have that power. You don't have that. Clear everyone in the class? That's all. This is the end of Ultravires. Last point still there. After that, I will be going for the questioning starts. Listen now. There is one very important case law. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Normal Ritchie, not Ritchie Rich. Very poor. Sir, listen. What happened in this case law? Please read the name of the case. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. This is the case. Let me give you the facts of the case. What happened? There is a company called as Ashbury Railway Carriage, Ashbury Railway Carriage and Iron Company Limited. Sir, for simplicity's sake, I call it A Limited. There, please. If you listen, I have to repeat 3-4 times. If you go to other world, how many hundreds of times I have to repeat the same point? See there. There is a company called as A Limited. There is a person called as a Ritchie. This person belongs to Belgium Railway Company. Belgium Railway Company. There is another company called as a Belgium Railway Company. This Belgium Railway Company will be laying the railway lines in Belgium. Tracks will be there, na? Railway track. India la railway track privatization happened after Narendra Modi. 2015-16 la privatization of tracking system came. Vande Bharat Express was made in 16-17 year, na? Vande Bharat, you know Vande Bharat Express? 3.5 hours lo you will reach. Now they are laying a track between Hyderabad to Chennai. For 4.5 hours we can reach our train. Now it is 12 hours. 12-hour track, because from Hyderabad, if you want to reach Chennai, from Hyderabad you need to come to one junction called as Vijayawada. From that junction you have to again go to Chennai. Vijayawada will become the center's main focal point. But now they are trying to make a divergent railway line. 4.5 hours we can cover, because that Vande Bharat Express will go at 180 kilometers. So they are making it. Plan started. Vande Bharat Express already running between Ahmedabad and Mumbai. Okay. So Varanasi, Delhi, there is a Vande Bharat Express. Like that they are planning. Like that they are planning in that particular case. Belgium Railway Company is there. That's planning a super fast track for Belgium. Privatization came. Government of Belgium said that whoever gives the contract, we will offer for them. They can do the contract of railway line. Belgium Railway Company came forward. Listening everyone, please listen. Okay, Belgium Railway Company came forward. That company went to A Limited and asked A Limited, we are going to lay railway line in Belgium. For that, you have to give me a finance. Ashbury Railway Company has to give what? Finance. Finance to whom? Belgium Railway Company. Finance means loan. What it has to give? Loan. Loan to whom? Belgium Railway Company. Who should give? A Limited. Who approached? Ritchie is the MD of Belgium Railway Company. Clear? Transaction up to here. Everyone understood the screenplay clearly? Yeah? Okay, done. What happened in this particular case law is, Belgium Railway Company approached A Limited asking for laying a railway line financing. A Limited can't directly make a promise. It has to check the memorandum whether really giving loan is there within their powers of memorandum or not. They have to check yes or no. Yes, sir. They opened MOA. MOA la objects are very clear. Everyone listening? Yes, MOA la objects are, hello everyone, please listen. MOA la objects are very clear. The objects said in the memorandum are as follows. See here, object is to sell, lease, hire railway carriages and wagons. Railway carriages and it also have, see here, it also can carry on the business of mechanical engineers and general contractors. What are the two objects? Object number one, sell, lease, hire, railway carriages and wagons. Railway compartments are there, na? Compartments. That compartment manufacturing is done by a company called as I'm talking about this case la. It will be manufactured by a company called as A Limited. Ashbury Railway Carriage Company will manufacture the compartments, wagons. It will be coaches. It will manufacture. Manufacture after what they will do? They can do three things. They can sell, they can lease, they can hire, rent. It can give it for rent, it can lease it, it can sell it. Clear? Those engines, compartments may get a repair or not. Repair work also those company only will do. Repairs for the engines, compartments will come under mechanical engineering works. Listening everyone? Tell me, what are the two objects of Ashbury company? Sell, lease, hire, railway carriages and wagons. Next, to carry on the business of mechanical engineers and general contractors. This is what you can do. Okay, this is the situation. Who approached A Limited? For what? For railway carriages and wagons? For finance? Now tell me, in the objects of Ashbury Railway Company, is there a concept of financing? No. Answer? No. But A Limited said that I will give you the finance. Without seeing memorandum, A Limited said to promise to whom? Another company called as another Belgium railway company. It promised saying that sanction, I will give you. How much money you want for laying? I will give you. It promised. Done. This Ritchie made all arrangements. They started taking all contract from the Belgium railways. In another 10 days project has to start now. This person Ritchie went to A Limited. As promised in the agreement, please give me the finance. This company, A Limited company secretary and advocate said that don't give loan. He was shocked. Why? You promised me to give. No, we can't. Because giving finance is not within the objects clause. Who said? A Limited's company secretary said, legal advisor. Listening everyone? Said that giving the finance is not within the powers of that company. It's not there within their powers. You can't give. Ritchie was angry in such a way that he said, I will go to the court for breach of a contract, anticipatory breach. I will file a case against you. I will collect damages from you. Ordinary damages I will collect. Contract was lost. Special damages also I will collect from you, he said. Also called as a vindictive damages. I will collect both from you. You are dead. I will go to court, he said. Company secretary said, go. Go, you try. You will only be lost. Court charges also lost. You will only be lost. So you go to court, no problem. Immediately, Ritchie belonging to Belgium Railway Company immediately went to the court and filed a case for breach of contract, saying that the company A Limited promised them that it will give finance, but at the last moment it is making a breach of contract of giving the financing and loan. Therefore, there is a breach of contract. File a complaint again as the A Limited and take damages like that. He filed a complaint. Clear everyone? Yes, court called both of them. First court asked Ritchie, first you come, you stand, tell what happened. He said, sir, my name is Ritchie. On a particular day I went to A Limited. I found a managing director of A Limited. I said the entire story to him that I am going to lay a railway line in Belgium. For that it costs lakhs of euros. I asked him loan. He said that yes, company will give a loan. Later on the last day when I went there, company secretary is telling that the company's objects clause of memorandum don't contain power to finance. Therefore they are telling we don't give. So therefore I want to file a case against him for not giving the loan. Like that he said. Now, argument from the defendant side. They also said the same, sir, we accepted. True, we are not denying that. But now I am telling you, sir, in our objects, power to finance is not there. Next, again it asks, now tell me, what is your argument in the case? As Richie said that, sir, I read their memorandum, they have power. But they are not giving me just to destroy my business. Court said, did you read MOA? Richie said, yes, sir, I read. Where it is, I couldn't see anywhere. Sir, general contractor. One of the object of Ashbury company is to carry on the business of mechanical engineers and general contractors. General means what you can do generally? Generally I can do anything. In that word general, finance also will come. General stores will be there outside. Huh? General stores you will find medical shop and general stores. You will find medicines, you will find comb, you will find a talcum powder, you will find what not, everything will be found. Generally what you can do? Generally I can do anything. Generally what you can do? What is general hospital? That's the meaning of general. Hello everyone. Richie said that, sir. Who said the objects are not there? Read objects properly. I think judge is not understanding objects class. You read properly what is there. Mechanical engineers, okay. And general contractors means what contracts it can enter? Any general contract. In that general contract, financing contract also will come. Judge got shocked. What an interpretation. Mechanical engineers and general contractors, general is used, therefore they can finance. So financing is there within the objects, therefore company can give a loan. That loan contract entered by company and they breached the contract, you are asking for damages, sir. How much law interpretation you made? But I am very sorry, Richie, this is not the way to interpret. Court said, we are invoking the rule of Ejusdem generis. What happened is the history. Listen. What is Ejusdem generis? Interpretation of statutes, one of the rule of interpretation says, the rule of Ejusdem generis. Meaning is very clear. Listen carefully. I repeat as many number of times as possible for you, but still listen. Today we are loaded with so many concepts, sir. I don't know which question I will ask you, so please listen carefully. If you want me to repeat, I will repeat once again. Listen. There must be enumeration. Enumeration means explanation. There must be enumeration of specific words. Specific words must be closed by general words, or you can tell that specific words are followed by general words. Clear? All the specific words used should fall into same category. All specific words used should not exhaust the whole category. The general words should be taken the meaning from previous specific words. This is the rule of Ejusdem generis. Sir, I didn't understand even a single word, sir. Therefore, I will explain you the concept. Maybe after that you can understand well. To apply the rule of Ejusdem generis, first there must be specific enumeration of certain words. These specific words should fall into same category. These specific words should not exhaust the whole category. Clear? Specific words should be followed by general words. That general word should import its meaning from previous specific words. Everyone repeat 5 marks question in examination. Tell me, what is rule of Ejusdem generis? Number 1. There must be specific enumeration of specific words should form under. Those specific words should not exhaust whole category. Specific words are followed by the general word should import its meaning from previous specific words. If all conditions are satisfied, then which rule will apply? Ejusdem generis will apply. So now let us go for examples. I said this way. Mr. A is a scientist who is doing research on. Okay, who is doing the research on Mercury, Venus, Earth, etc. I said Mercury, Venus, Earth, etc. Now tell me what will come under that etc. Entire universe will come. I am talking about what here? Which planet? Planets, there are so many planets in this earth. Which planet? Planets in which solar system? Solar systems are so many are there. Our solar system. We are talking about the solar system where Earth is rotating. Sir, okay. Now listen. Listen. Now the point is, Mr. X, a scientist, is doing research on Mercury, Venus, Earth. Are specific words. Okay? Listening? 3 specific words, whatever I have used, falls under same category. What is the same category? Solar system, our solar system, all the 3 falls under same category. A condition satisfied. Tell me, I gave the list of all planets, only 3 are. I didn't give entire list. Next, specific words, Mercury, Venus, Earth, etc. I said. Okay, etc. is which word here? General word. It's not a specific word. General word should take the meaning from the previous specific word. From the solar system only, other planet names we should take into that etc. Not everything in this universe. Understood or not? Now, second example. I have fear towards lion, tiger, leopard, etc. Now tell me into that etc. what has to fall? All ant, mosquito, fly, everything will come. I am talking about wild animals or normal. That too 4-legged wild animals I am talking about, which can run and hunt us. Reverse there wild animals. I am talking about those only should come into that. Clear everyone in the class? Yes, third example. You are saying like this. I went with my friend to, say for example, Kanchi, Tirumala, Srisailam, Dwaraka, Rishikesh, etc. You said. Okay, etc. Now tell me, into that etc. what should fall? Any place, only pilgrimages. Because, tell me, what? All the points in the rule, whether applied or not, let's check. First one, there must be. Here, what are the specific words? Kanchi, Tirumala, Srisailam, Dwaraka, all these are what? Specific words. Specific words, all specific words belong to same category or not? Yes, sir. Third one, all pilgrimages I said that? No, only some I said. And I use the word etc. So that etc. should take the meaning of anything. And Goa, all things will come. I am talking about what? Pilgrimages. Only pilgrimages should come inside it. Clear? Reverse. You said, I went with my friend to Goa. I don't know. Or 2-3 places you said. And you use the word so on. Now that so on will include Thirumal Tirupati Devasthanam. Your eyeballs will pop out. So therefore, that does not include. Why? The specific words I am using are not tourist places. Those are all for a normal trip. Now did you understand the rule of Ejusdem properly? That's how the rule actually will apply. Okay? One real life example, these are all general examples. One real life example let us take. One case law happened in Honorable Hyderabad High Court. What happened? Let me explain. There is a company called as a AP Hatcheries Limited. AP Hatcheries. Egg hatchery will be there, na? Listen. Egg hatchery company is there. This happened way back in 2004. 2004 year la Andhra Pradesh state government has released a GO for promoting promotion of poultry and poultry products in state of Andhra Pradesh. They released a government order, GO they passed, and it became an act later. Indian Poultry Act is there. Into that act, Andhra Pradesh also have given their consent. Sorry, law what it said I will explain. You listen carefully. Government shall provide a one-time subsidy of, I repeat, government provide a one-time subsidy of 50% of the cost of the project, of that poultry project. Clear? 50% of the cost of the poultry project will be provided as a subsidy by the state government of Andhra Pradesh. For example, your investment cost of the project for that hatchery, say example 10 crore. 5 crore government will give you. 5 crore you have to spend. Clear or not, everyone in the class? This is the idea of the government of Andhra Pradesh, just to develop and enhance the promotion of poultry and poultry farming in the state of Andhra Pradesh. Am I clear? Beyond that, they also said like this. 50% subsidy on the 50% subsidy on the eggs of hen, emu, and so on. Emu bird will be there. Emu bird. It look like an ostrich, not completely. Like an ostrich it look like. So, please. There are many birds which lay eggs. They use words like this. Okay. Subsidy, 50% subsidy will be given on the eggs of hen, emu, and so on. Like that they used. One great person came to the government of Andhra Pradesh. AP Hatcheries department is there. Animal husbandry department. He came there. He said, government has to give me 50% subsidy. I am also having eggs to lay. We are having a hatchery. I will give you the eggs. For that, you have to give subsidy, because a hatchery required a temperature maintenance. In that incubators, we need to put the eggs. They will hatch at the temperature perfectly. Therefore, that equipment requires lot of cost. Around 1.5 crore. 50% government, if they give a 50%, I will bear, he said. Government said that, okay, bring. We will definitely do the subsidy as promised. Matter went to the government. Government said that, twist I will tell you at the end. So he went, application received. Government twist, this type of application came. They immediately called that person, "Arey, what is this going on? On this we don't give subsidy," they said. Sir, what is that? What is that egg that he brought? Question will arise now. Those are snake eggs. Okay, snake eggs. He is a person who catches reptiles in forest. So that person gave around 6,000 eggs. Okay, that person is the person who will collect the snakes from the forest and give to the nearest zoo. The person livelihood is catching snakes. What this person have done, brought all the snake eggs. He came to know about this law. Someone, he thought so on means everything will be included. Hennu, emu, so on. And whatever can lay egg will come into this. Are you understanding or not? Immediately he went to the Andhra Pradesh Poultry Department. He said, please give. They were shell shocked literally. They said, "Arey, on this we don't give." He said that, "Why you will not give? What is there in the rule? Please read for me." Hennu, emu, etc., etc. So on. So on, this also will come. Arey, so on, how this will come? Why it will not come? Tell me. You are telling why it will come. Now I will ask him why it will not come. Give me one reason. Poultry department don't know Ejusdem generis. Matter went to Honorable Andhra Pradesh High Court. High Court judge also shocked. Arey, who is that fellow? Please call him. They came. You stand last, don't bring snakes to court. Stand there. Tell me what is your problem. Sir, as per government order it was given, sir, so on. Therefore, snake is also coming under, sir. So therefore, please give subsidy to me, 50% subsidy I also want. Then court said that, I am very sorry, you are a great person catching snakes, we don't deny. But still, government is not in so much a generous situation to give, this subsidies to you, because I said, hen, emu, etc. means ostrich, other birds will come. Now tell me, hen, emu, ostrich are coming under reptile category, birds category. Now, specific words belong to the same category. I use the same category, na? Next. Specific, I said all the names of birds. No, I can't tell. Therefore, I said some and I have said so on. So on is a general word. So on is a... That so on should take any meaning from the previous specific words. What is the previous specific words? Birds. Only that will come. I am very sorry. You lost your case. Please leave the court, they said. Everyone understood? Along with snakes. You please leave the court. Never come back again. So this is the judgment given. Now listen, same concept applies also in Ashbury case law. Ashbury case also went to the court. Richie said that, sir, that company has objects, financing is there. Court asked where? General. Oh, so they can do generally anything. Yes, sir. Matter went to the court. Court said that the word general is used in connection with the word mechanical engineers. Therefore, the word general is any kind of servicing in mechanical engineering they can do, not anything they want. Therefore, financing is outside the scope of this company. Therefore, it is ultravires, not ultravires. Ultravires, you can't file a case against another person. Ashbury company is not liable to give finance. This is what given as a case law judgment. Everyone understood the concept clearly, yeah? That's the idea of that concept. Institute booklet, they have given one small answer. This much explanation they didn't give, but still, this is the answer. The court held that the term general used in the objects clause covers only such contracts which are relating to mechanical engineering, and since financing is not covered, the contract is ultravires and no party can sue another, because ultravires is valid void ab initio. Void ab initio, one cannot sue another. Classic examples are A contracted with B to kill C. Okay, na? Really, I am asking. See here, A entered into contract with B to kill whom? Now, listen. Who asked to kill? Who is the person killing? Who is getting killed? B killed C, but A didn't pay money. Can B sue A in the court? Reverse. Reverse. A gave money to B, but B didn't kill C. Now can A sue B? Why in both the cases no one can sue another? Same happened also in this case. You can't sue him, A can't sue you, no one should sue, you go first. Ashbury can't sue another, another can't sue Ashbury. Case A close. Everyone understood the concept? Now we completed fully the concept of Ultravires under Companies Act. With this, all the doctrines have been completed. Tell me, what are the 4 doctrines? 3 doctrines. Constructive notice, doctrine of indoor management, doctrine of ultravire. In middle, one thing is there in doctrine of indoor. Exceptions to the rule of doctrine of indoor management. Everyone understood the concept clearly, yeah? So with this, we have completed all kinds of doctrines as well. We completed 14, 18, doctrine of constructive notice, indoor management, exceptions, ultravires, case law, everything covered. I will give you a 2 minutes time. Constructive notice, indoor management, you already know. This one you read. Our question hour start. As per you, I didn't understand. Take this. Hello. One second, please.
According to Ultravires, if the MOA does not permit the company to do a particular thing, and if the company wants to do it, it can pass a special resolution.
It can alter MOA. That's all, huh? It can do. Next, any questions? Yes. Not Rishi, Richie. Either spit that bubblegum or chew that bubblegum. In middle if you do na, this is the problem. Now tell. Huh? No, they cannot. They cannot. It's your mistake of not interpreting the general properly. Next, any questions? Any questions, everyone? Anyone in the class? From the last till first, any questions to ask? Then 2 minutes time for you, max. Then my time starts. Till now you are saved happily, you are sitting and listening. Yes. One second. I will give the mic. Pass it on, please. If they use
Ant, crow,
and
tiger.
ant.
Crow, tiger. Then
One second. Ant,
crow,
crow, tiger.
etc.
Now you can't use that because all the three does not belong to same category. Rule of Ejusdem generis does not work. Everything you need to specify clearly then. Yes. Good question. Yes. Take the mic.
Sir, in the specific example where
One second, please. Please.
Sir, where in the specific example where you said that by using and, they won't belong to the same category. Sir,
And.
by using the word and,
Ant,
they won't belong in the same category because
Yes.
one is of birds and another is of animals. So by using the word and, will they be, sir, will the rule be exhausted, sir? That is in the definition. Adi exhaust avutundi kada, sir?
I didn't
And
understand. I didn't understand what. Arey, will you please stop talking? I couldn't understand what he asked. Please. You ask now.
Sir, in the specific example, we used birds, and she asked about after adding the word and having wild animals into the list. By using the word and, will the list become exhausted? No, sir, because it won't be specific, right?
Exhausted means, what do you mean by exhausted?
Exhausted means after that there won't be anything left to be interpreted.
Then ant means it covered every insect.
By using the word and, will the list become exhausted? And
Yes,
sir, and sir, by using the word and, will the list will become exhaustive? No, sir, it won't be inclusive of every other animal.
Why?
A and D, sir.
She is asking about ant. You interpreted and. Arey. No problem. If you use the word end also, for example, if I use the word, he is doing research on Mercury, Venus and Earth. Okay. Then I will not use the word etc. Then where is the scope of using Ejusdem generis? If really I am doing research only on 3, and after why we will use etc. again? I will not use. Next.
Sir,
Who is that?
in the given case study itself, sir, there may be multiple interpretations possible, no, sir. The government may think of only which is useful for broilers, that will be given subsidies, but they can grow some crows or which is not at all useful, no, sir.
Yes.
Which falls in the category of birds, but it may not be.
That's why I am telling you, which are under poultry. Poultry means it should be hatched and used for human consumption. Those only should come. There is no multiple interpretation possible. Crovex you eat by omelette. Then where is interpretation here? No. Poultry is the clarity there. He made wrong interpretation. That's all. Next. Next. Anyone have the questions? ICI, sir. Please pass the mic. ICI, herself has a doubt. Pass the mic. Pass on the mic. Now class is going to experience one doubt.
Sir, she said ant, crow, lion, etc. So then how will we interpret, sir? Like, is everything included in that?
That's first point. That type of line itself, act, don't write. Lawmaker don't write like that. Ant, crow, animal, pig. Again, after law paper, they will not write like that. Irrelevantly. She asked a question extraordinary. Again, you are asking doubt on the question. Really, you are ICI then. Next. Yes. Pass on the mic, please. I understood students are very smart. By asking these doubts, they will make 6. I know about you. Last doubt. Last doubt. One second. Hey, Gammunundava. One second. Listen. One nimisha.
Sir, if under section 181C, ceiling is 150 crores, sir, but MOA allows the company to borrow till 200 crores without special resolution. Which is override now, sir.
1 minute. I couldn't listen.
Under section 181C,
Yes.
the ceiling comes to 150 crores, sir.
Yes.
If the MOA allows the company to borrow till 200 crores without special resolution, which will
No,
override.
you cannot. Section number 6 we didn't read. MOA and AOA cannot override the act. Section 6 is there. We didn't read that. We have to. Section number 2022, after we will read section 6 at the last to this chapter. At that time I will explain that. But MOA, AOA can't override act. Even if you write now, that provision becomes void.
Okay, sir.
Yes. So everyone, Pakkana? Now I have questions to ask. Which one? No need to read. Insult. Thupuk. How many times I repeated today? Same answer. Again you want to read? No? You Mike? I will call persons. Fatafat come to class. Last row. Yes, bro. You. And person after you also. Both come. Da. No, not him. Abba, Nana. Too much ultravires. Come. Bro, you also come. Bro, you can sit there. First he will come. No, not you. Ultravires vanda. Come. You take this. Come here, stand in the middle. Okay, na? See them. Answer question. Question number 1. Shall I ask question? Very good. Question number 1. What do you mean by ultravires?
Beyond the powers.
Powers of dash. Beyond the powers of, what are the chances are there?
Beyond the powers of Act, beyond the powers of MOA, beyond the powers of AOA, beyond the powers of Board of Powers.
Very good. Next. What is the effect of ultravires transactions What will happen if you enter into ultravires transaction?
Beyond the powers of Act and beyond the powers of MOA, it's null and void.
Very good. Next.
Beyond the powers of AOA and beyond the powers of board members, voidable. It's voidable.
Ultravires or intravires?
Ultravires the board, ultravires the AOA, but intravires the MOA.
Oh, super, super. Done. Very good. Give mic to him, you can go. You have a problem, huh? You sit and answer then. Sit and answer. No need, you need not come. Question number 1 for you. What will be the impact of ultravires transactions? Legal, I will ask questions, answer one by one. Okay, legal or illegal? Ultravires the MOA. Legal or illegal?
Illegal.
Illegal. Very good. Next, who will be liable? Company or directors?
Directors. Directors.
Very good. Next, what are the 3 situations under which indoor management does not apply? Exceptions to indoor management. Yesterday I told, director know about. Yesterday you came, yesterday I gave the last before the class I said, director, Turkwan case, T is a director. What I said? He has a
Knowledge of
very good, correct. Continue.
irregularity. Knowledge of irregularity.
Very good. Second. Next, now I said patent ivory company, Howard. Now today's class, accountant went, took loan, without making any inquiry, he gave to account.
Faith.
Huh?
Good faith.
No. Suspicion.
Suspicion.
Next, what is the third case I said we will be discussing in share capital chapter? Third case of
Forgery.
very good. Thank you very much. Thank you. Take care. Next. Bro, I will not ask you. No problem. You need not see mobile phone all of a sudden now. Last bench. I need not ask you today. Okay? Be safe. Hurriedly he is opening for Ultravires he is reading. No problem. I am not going to ask you. I been that row over. Next. Ingaro. Who is there? Whose face pretends to be innocent is the most dangerous person in a row always. In face he tries to, listen, in face he tries to be more confident. That person is not confident. But he tries to pretend. We see so many faces every single day. At class, acting time, every time when we put a camera before the face, when we make short films in Hyderabad with an entity called as Chai Biscuit, when we make action, we used to put camera before the face. Okay, we used to tell, cut, camera, action. We will give a scene paper to them. This is a line you have to tell. Then all of a sudden they will laugh. Okay, sometimes we will tell, Arey, put some anger on your face. I will tell them, don't constipate. I am asking you to put face angry. Like that, whenever I ask a question, immediately faces will change. Who will come? This row. Bro, you come. Lucky fellow. Da. Aja, take stage, come, stand, answer. Question number 1. What is Doctrine of Indoor Management? Hey, don't leave the class. Come in. Hey, stop him. Come. Close the door. For any emergency, do here only. So, don't leave the class. Bro, you answer.
Exception to constructive notice.
What question I asked you?
What is indoor management?
What you said?
It is an exception to
Oh, okay.
constructive notice.
Sare, okay. Exceptions to?
Constructive notice.
Very good. Beyond that, what is the meaning of indoor management?
Outsider who understand MOA and AOA in a right sense, and he will be protected by indoor management.
Continue here, I am not doing anything. Outsider?
Who understand AOA and MOA in a right sense, he will be protected by a doctrine of indoor management.
Okay, continue further.
He will presumes that a company has strictly followed the internal regulations.
Very good. Next, what are the exceptions? Exceptions of indoor management.
Irregularity.
What irregularity? Knowledge or no knowledge of irregularity?
Knowledge of irregularity.
Next. Just now I asked that, bro. What you have done at that time? Oh, you thought that that question will not be asked again,
Suspicious.
Correct. By chance you said, but that is correct. What is that?
Suspicious.
Arre, loudly you tell here you are correct.
Suspicious.
Very good. Third?
Forgery.
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 Very good. Thank you very much. Next. Who is the black sheep? That black t-shirt fellow. Come. No, not you. In front. Yes, I always choose a right person in a bunch. So come. Acha. You are listening to songs or listening to class? Answer now. Question number 1. What are the topics we discussed today?
Doctrine of indoor management.
Very good.
Doctrine of constructive notice.
Very, very good.
Doctrine of ultravires. Ultravires.
In middle.
Exception.
Very good. First tell me, what is doctrine of constructive notice?
Doctrine of constructive notice. It was not there.
Wix you want, Okay, sorry. Don't feel that much uncomfortable. Thank you. We'll meet tomorrow. What's his name? Balua. Balsumanyan. Balsumanyan should have a proper throat here. Sorry, okay. Next. Who will come from this row? ICA, no, today. Wildcard entry every day. Ma'am, you come. Back. Yes, come. Don't get surprised. Why I should? Oh, no, not you. Middle. Yes, come. Why so surprised? Give one mic. I will ask you question on. Come, I will tell. Come. Acha. Tell me about doctor. You can stand. Face the crowd. Tell me, what do you mean by a doctrine of constructive notice? Tell them, not me.
Constructive notice is to...
Stay stiff. Please tell.
Constructive notice is to protect company.
Don't tell to me. First point. Don't tell to me. When class is going on, I say, doctrine of indoor management means whenever the company is constructive. Did I tell like that? Address people properly first.
Constructive notice is to protect company against the outsiders.
Next, continue. But that is not the proper answer. From beginning you have to come.
when a company is incorporated, MOA and AOA
Very
are
good. That is the
public
beginning.
documents.
Ah.
So everyone can be freely accessible to it. The person who is dealing with the company should read MOA, AOA in a right sense and understand in a right sense.
Then what will happen if you understand in a right sense? I will ask question, answer. It is a doctrine protects whom from whom?
Protects company from outsiders.
In favor of whom?
In favor of company.
Against to whom?
Outsiders.
Very good. Thank you very much. Another person. This row over kada. For change. Let's call another person from the same row. Anyone to come? Sorry, okay. First I will complete another row. Samanyayam. Let's complete every row. 1, 2, 3, 4, 5, 6, 7, 8. 8. Last. Madam, you come. Come. You attended yesterday's class? Today's class? Means actively present on. That's my question. I take this. You come and stand. Question number 1. Tell me, in my example, hey, listen here. In my example, 150 crores is the paid up share capital free reserve. First tell me what is 181C section?
181C section.
Sir, I will ask question. What is LHS?
Existing borrowings plus proposed borrowings.
Very good. Should be less or more?
Should be lesser than the aggregate of paid up share capital, free reserves, securities premium.
If it exceeds, what will happen?
If it exits, the company should get a special resolution from.
Okay, in our example, SR not passed, what will happen? MOL power is there. SR not passed, what will happen?
Yes.
Remember the chart. Take time, no problem. SR not passed. Beyond limit, what will happen?
It becomes irregular.
Correct. Tell them. Transactions becomes
irregular and voidable.
Very good. Ratifiable or not ratifiable?
Ratifiable.
If it is not ratified, what will happen?
If it is not ratified, it becomes legal, void.
Void. Then outsider can recover or cannot recover?
Outside.
Up to what extent he can recover? Up to what extent he cannot recover? Tell me that.
Within limit, it can recover. Beyond limits, it cannot.
He cannot recover. Beyond limit, he cannot recover. He cannot recover when?
If he cannot recover, if he does not have the knowledge of irregularity.
No. He does not have a knowledge of which doctrine?
Constructive notice.
Very good. Thank you very much. Thank you. Next. Who will come? Maybe some students are doing stunts also. When I am in this row, they are going there. When I call one person from this row, they are coming here. That also I should keep in mind. And from then I have to scan faces. Next. Who will come? Anyone, if you want to come, you can. If you are leaving selection criteria to me, I will select a person. Ma'am, you come. Come. Attended class? No, back. Attended class today? In class? Listen yesterday? Then come. You are eligible to answer questions. Come and stand. Question number 1 for you. Which question? Tell me, what are the conditions you need to fulfill to convert companies? Public, private, public. Tell. First you need to alter what? Sorry, I will ask on doctrines, sir. Yes. Shall I ask on doctrines? Then see them. Question number 1. What are the exceptions to doctrine of indoor management?
Knowledge of irregularity.
Loudly tell them.
Knowledge of irregularity.
Second.
Suspicion.
Next.
Forgery.
Next one?
Forgery.
Forgery. Okay, done. Next. Next. What will happen? What is the impact of ultravires? Sorry. First tell me what are the 4 types of ultravires transactions that can happen? Ultravires Act. Like that I said. Now 4 categories. Tell me that.
Ultravires Act, Ultravires MOA and Ultravires AOA, Ultravires Board of Directors.
Very good. What will happen in the first 2 cases?
It is null and void.
Next 2 cases?
Irregular.
Irregular means valid, void, voidable.
It's voidable and it is intravires the MOA and ultravires the Board of Directors.
Very good. That can be ratified or not ratified?
Can be ratified.
Ratifiable. If ratified, what will happen?
If ratified, company will be liable. If not ratified, Board of Directors will be liable.
If ratified, irregular will become? If ratified, irregular will become? You are telling that ultravires the board powers is irregular. Okay? Now irregular will become?
Valid.
Very good. Done. Thank you. Next. Next. Who put innocent face? Only those will be called for. I can't do anything. After TV also some okay, only one person is sitting. Now, madam, you come. Yes, correct. Come. You attended yesterday's class, huh? Tell me, what is the procedure to convert a company from one company to another, public to private?
First, Board of Directors.
Please.
Board of Directors should give the approval first.
Next.
Then shareholders should pass special resolution in the general meeting.
Why?
So to alter the MOA.
That you should tell. Don't tell shareholders has to pass. Because of MOA they are passing. Because of their passing, MOA will not get altered. So first alter the first one, board approval. Next one?
Shareholders approval.
Again you are telling the same. Second one is alter MOA. Next.
Shareholders approval in special resolution. Next for public to private.
No, to alter. Articles also you should alter, na? Mali come from the beginning again. First one?
Board of Directors should approve.
Next.
MOA should alter.
By passing?
Special resolution.
Next.
AOA should be altered.
By passing?
In case of
by passing?
Special resolution.
Next.
In case of converting from public to private, unanimous approval is required. So private to public, unanimous approval.
Oh, don't write Companies Act 2022 December edition. I didn't tell that. Unanimous approval came only in entrenchment. I am asking conversion, central government approval, public to private.
Public to private, central government approval required. For private to public, removal of those restrictions itself convert the private.
Central government approval required or not required?
In case of private to public, not
required. What is it when it is required?
Public to private.
Very good, thank you. So, everyone understood all the concepts clearly, yeah? With this, we have completed fully the concept of doctrines as well. Next session, we will complete balance concept. Today, in my plan, section 10 is also there. That only one section I couldn't cover. Remaining everything as per the plan, we covered everything. Section 10 also I tried to cover, but the time is not sufficient. 10 minutes only there. In the 10 minutes, I can't even give you introduction. Anyway, 10 minutes or 10 times again, you will be, I have to repeat that. Time is not enough. It takes 25 minutes time to 30 minutes. Tomorrow's session we will take it up. And tomorrow after that, we are going to start with another area called as incorporations. There are 6 topics inside incorporation. Once that is covered, 95% of this chapter will be over. So by tomorrow's session, we complete 95% of this particular chapter. Clear? So thank you very much. Have a nice day. Bye.